But besides when I'm going to one track. Oh, but that's the same country. So I could have, but I couldn't for that. I could have, but I got really nervous. Like, remembers it, and I like, you know, like I was like not about to do that. But I actually like it a lot. Like we're learning. I like just because it's kind of like a Jersey. Yeah. Yeah. So I do like it. Good. How are you? You like that weird? Yeah, exactly. Okay, thank you so much. I could have told him that. You got him. That would have been amazing. And then he started oh, there you go. Anything. Thank you. I appreciate it. The problem is, you and I may be doing and then HR not well, I appreciate I got accepted into 3 PhD programs. Running a my baby. Boy, I had to have people write extra letters because I was so awful. Got it, and it worked out. I don't work. I got like rejection. Now look at me. Yeah. Oh yeah. Oh yeah. All right. And then there's my time. So like you got to that level. Well, we experimented on in our basement for a month. We do? Well, I'm like mother of the year. Yeah. So, yeah, can't help but communicate with you. That's my story.
I've also, I was really disappointed. There's no makeup. I wanted to make sort of.
Oh, yeah, with red dot, blue color.
They didn't go for it. Sorry about Easter. Cold. Thank you. I'm freezing. I tried to put my door on. Weird.
How are you?
It's fine, it's just,
For me, I can't do it right. I'm I hate being coached, but it's been back here. Yeah, so I felt really big around 40 minutes, but I had 5 pelvis is raised in my lower back, so I have all kinds of
Actually, it's like it's no time. You're all right, I'll introduce you and then I'll call him on.
Nathan, how long are we gonna have like it's gonna be?
I'll explain. Okay. 10 minutes, 5 minutes, 5 minutes.
This is gonna happen every time
Good afternoon. On behalf of Adrian College's George Romney Institute for Law and Public Policy, welcome to today's debate titled, Does the Constitution Allow Donald Trump to be President? Before we begin, I'd like to thank President Docking and the Adrian College senior staff. Their support for the Institute makes these debates possible. I'd also like to especially thank Romney Institute intern Avery Kelly and my good friend and colleague Jason Smart, who for years has given his time and considerable talents to designing the posters for the Romney Institute events. His posters are works of art. I want to especially thank him for his service to the Institute. The Supreme Court is now considering whether a former President Donald Trump's role in the January 6, 2021 riot that resulted in the breach of our Capitol disqualifies him from returning to office. Next to me are two accomplished lawyers and professors who have different views on this question. Today, they will explain their conclusions and be challenged by us and by one another. Professor Aman McLeod holds a law degree and a PhD from the University of Michigan and teaches constitutional law at the University of Detroit Mercy School of Law. He is a prolific scholar and a widely respected teacher. Professor McLeod will be arguing that Donald Trump is barred from holding office. After graduating from Michigan State University, Professor Stephen Doolin earned a full scholarship to Thomas M. Cooley Law School and has been teaching at his alma mater for at least 20 years now. Is that right? Time's flying by. Professor Doolin is a renowned litigator and expert on constitutional issues, appearing on CNN and other national broadcasts as an expert advocate for his views. He's also a standardized test guru whose genius IQ has earned him membership in the 999 Society, which represents the top 5% of Mensa members. Over the years, Professor Doolin has worked with numerous Adrian College students and as a law school aptitude test tutor and mock trial instructor. He's helped countless Adrian College students over the past few years, and I'm especially grateful to him for that. Please join me in thanking our guests. The format for today's debate will be as follows. Professor McLeod will argue that President Trump is disqualified from holding office for 10 minutes, followed by Professor Doolin, who will spend 10 minutes arguing the opposite. Professor McLeod will then respond for 5 minutes, followed by Professor Doolin. The remainder will consist of questions for either speaker or both from the audience. I hope you'll challenge these debaters with thoughtful questions that compel a stronger defense of their views. I have no doubt they can handle it. Professor McLeod?
Thank you. First of all, I want to thank Nathan for inviting me today. This is my second event at Adrian College. I really enjoyed the first, so I was happy to be invited back, and thank you all for attending today. I just want to, for those of you who might not be familiar with Section 3, I just wanted to read it. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as any member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. Okay. This is Section 3 of the 14th Amendment. The 14th Amendment is one of the what's known as the Civil War amendments. These were enacted in the wake of the Civil War to deal with the problems that both caused that war and resulted from it. one of the, it was adopted in 1868. The 14th Amendment is better known probably for the other things that it has in it, including the Equal Protection Clause and the Due Process Clause that apply to the states and things of that nature. But Section 3 was put in there in order to address the issue of people who had officials, people who had taken an oath to uphold the Constitution and to support and defend it and to protect the country and uphold its legal and political order, who had betrayed that oath by taking up arms against it or by supporting a government that was intended to break away from it illegitimately. Okay, and so that's why it's there. In the interest of time, I'm going to just jump now directly into the arguments some of the arguments that former President Trump has made about why he should not be disqualified under this section. Okay. Okay. First, he's argued that he hasn't been convicted of any crime related to insurrection. Right? He has not been convicted in a court of law of any crime related to that. Arguments have been presented by both the state of Colorado, which is also a party in the case of Trump versus Anderson, and others, that a criminal conviction isn't required under Section 3, under the text or under either the text or the original meaning of those words. In addition, the distinction between civil and criminal proceedings, again, it's an important aspect, but civil proceedings also are a venue where accusations can be made and defenses can be mounted. The suit in which Trump was, in which the courts in Colorado ruled that Trump was ineligible, created an opportunity for him to defend himself against the allegation that he had engaged in insurrection. So the idea that he did not, quote unquote, get his day in court, that's simply speaking not true. He did, because he had every opportunity, and he did present a fulsome defense in that case against, and one of the allegations was that he had engaged in insurrection, and he presented a defense, and that failed. But it's not that he didn't have an opportunity to do it. Okay. Also, there is absolutely no general requirement in Section 3 of a criminal conviction. In the immediate aftermath of the Civil War, after the adoption of Section 3, civil suits were mounted to get people disqualified at the state and at the federal level, and they were successful in the sense that they were not overturned. So we have a precedent for not only basing disqualification in Section 3 on a criminal conviction, right? So there's that argument. Another of Trump's major arguments is that he, as president of the United States, is not an officer within the meaning of Section 3. His legal counsel went into this in great detail, but in the interest of time, I will just simply say that if you go back to the original public meaning of the word officer as it was used in the late 1860s, officer is anybody in a position of leadership in government. The word itself, I would say pretty clearly, encompasses the President of the United States. Because the President of the United States is a person who is in a position of leadership in the United States government. The person that office is the Commander-in-Chief of the United States. That office has enormous power to direct the government and do everything else. That is what officers do, right? There's also, again, I don't think I have time to get into the complex textual arguments, but I would just simply note that Trump, in another case in front of the DC Circuit regarding a lawsuit against him and whether or not he had immunity under federal law as an officer of the United States, he was being sued actually for having violated municipal laws in the District of Columbia by how he was running his hotel. If you guys recall, he had the Trump Hotel in the old post office. He successfully argued in front of the DC Circuit Court of Appeals that he was an officer of the United States and therefore entitled to immunity, that the text of the statute that he was citing granted to officers of the United States. His lawyers made that argument successfully. So I'm not aware that they've tried to argue that officer meant one thing in that statute, but it means something completely different in Section 3. Also, I would just simply say one more thing. If the president and the vice president, which is Trump's argument, are somehow not covered by the notion that if they were to betray their oaths to protect and defend the Constitution, that they alone, among all other officials in America, senators, governors, whatever, just those two, they can betray that oath and not be disqualified under Section 3, but nobody else can. I call foul on that. That's incoherent. Why would you say that the official that has the greatest opportunity to subvert democracy is the person who is not disqualified by attempting to do so? I mean, it makes no sense. I would argue, but whatever. Okay, moving on. Did Trump engage in insurrection? Again, he had an opportunity to fully air that issue, but I would just urge you all to read the report that was put out by the United States Congress, who investigated in 2021 and 22, that investigated the January 6th uprising. There's ample evidence that President Trump planned to facilitate an effort to disrupt the counting of the electoral votes and to frustrate that. I mean, even everything from telling the National Guard to go into a more relaxed posture in the District of Columbia so that that it would be harder for them to respond to anything on those exact dates. So, I think there is the Colorado courts and other officials that have considered this are acting on I would argue, very strong evidence that Trump did engage in an attempt to overturn the lawful constitutional processes of the United States government. Another argument, and this is the one that a lot of observers feel, what's my time?
Got two.
Okay, and this is the one, I'll wrap it up here. This is the one that a lot of observers feel is the one that most likely will be decisive in the Supreme Court case that was just, the oral arguments were just had. President Trump has argued that it's not that he can't be ruled ineligible, but that the Section 3 is not self-executing in the sense that legislation by Congress is necessary to create a procedure that can be followed either by the feds or by state governments to enact, sort of operationalize Clause 3 and rule people ineligible so that they can't be on the ballot. I would just simply say that no other, and of course the argument there is that if there isn't one procedure, what we'll end up with is chaos, where there will be some states where the president is on the ballot or where officials would be, or somebody who ran for president would be on the ballot, and others where they wouldn't be. There would be different procedures in different states, different opportunities to air the evidence, and so on and so forth. To argue, to opposing that, I would simply say the following. No other part of the 14th Amendment is considered to be non-self-executing, meaning all of the rest of it is considered to be. So in other words, if I got a due process claim under the 14th Amendment, I can just make that in any court in America. If I got an equal protection claim, I can make that in any state, in any state court in America. I can make that exact argument. Congress doesn't need to pass any legislation for me to make it. I can just do it. The text of the 14th Amendment does not in any way say that legislation is necessary. Back again immediately after the passage of Section 3, states and federal prosecutors, without the existence of such enabling legislation, successfully brought suits to get people declared ineligible. So obviously we have a precedent for it working without enabling legislation from Congress. We have that. And the rest of the 14th Amendment doesn't require it. And the text of the 14th Amendment doesn't require it. So why would all of the 14th Amendment not need enabling legislation except for just this one part? Even when the language isn't there. So these are just the main arguments that I wanted to touch on. So did I make it? Okay.
Perfect. Thank you.
Thank you.
Thank you.
Professor Doolin, 10 minutes.
Hard act to follow, a lot of energy. I don't know if I can match the energy level. Context matters, right? This case involves hundreds of pages of briefing. You can go to the Supreme Court website if you're interested in reading any or all of. I doubt anybody has read all of except for the poor clerks who work for the justices. That's about it. The context matters when we're talking about the Constitution. We have to understand the history. Language is subject to interpretation. Any word, nearly any word, can be interpreted in different ways. We've got a word in the 14th Amendment, which is what's at issue here, insurrection. So where do you go for definitions for insurrection? Well, the first place you go is, if you're a lawyer or a law student, you go to Black's Law Dictionary. Turns out it's not in there. So we go to the federal statute. There is a federal statute. It's got a weird circular definition of insurrection that uses the word insurrection in the elements of the charge. So that doesn't really help you define what an insurrection is, except now we have to go to the sort of next level. The normal process is you go to popular dictionaries. If you look at popular dictionaries, they almost all involve violence, a call to violence. And this is sort of tangential to the arguments that were done at the Supreme Court, by the way, because it was all about exactly what my opponent was talking about, which is the definition of the words within the 14th Amendment and the meaning of self-executing and all kinds of legal concepts that, frankly, we don't have time to go into right now. There are practicing attorneys and professors who would have a hard time getting up to speed in 20 minutes on something like this. So what we have to talk about is, was there an actual insurrection, and was President Trump involved in the insurrection? That matters. And what you've heard is correct. The argument is that there was no criminal charge, but there was a civil action, there was a civil trial, and what you need to remember is there are different standards of proof. So there's a Colorado trial court who decided that there was sufficient evidence of insurrection to disqualify President Trump, but a criminal charge involves a higher level of due process, a higher standard of proof, where the prosecutor in a criminal case has to prove beyond a reasonable doubt that this occurred. Is it necessary that there be a criminal conviction in order for disqualification of an officer of the United States? Arguably not, but this case would be a lot more clear if there had been. And the other part of the context that matters is we know that there is no lack of appetite for pursuing President Trump. He's been charged in numerous courts with various things criminally and faced many civil suits that are still pending and criminal charges that are still pending. So if the January 6th committee, as was mentioned, they put out a heck of a report. If you ever have insomnia, read that report. But if you read that report, there's no basis in there for claiming insurrection under the federal statute, which exists. The other thing you have to keep in mind is the president, there is a good logical reason. I'm going to handle this argument even if it takes the rest of my time. There is a good logical argument for excluding the president and the vice president from the 14th Amendment disqualification. The disqualification is you can't hold office if you've been involved in rebellion or insurrection against the United States, right? And the context there historically is we're talking about a bloody civil war. The history of the United States is bathed in blood, as you're aware. This country was founded in an armed revolution. The modern United States was formed in the post-Civil War era. And it matters that what they were talking about was preventing Confederates and Klansmen from holding office. That's what this law is about, the 14th Amendment. This is about people who wouldn't hesitate to kill and torture to get what they wanted. And the goal was to prevent these folks from weaseling their way back into the federal government after the Civil War so that they could do some sort of a war from within, right? become part of the beast to fight the beast kind of thing. So what they were worried about was this. There'd be an elected president. Remember, we've got a one-person branch of government, right? The executive. That there'd be an elected president, but then when that president gave orders and directives and commands to all the people who actually carry out those orders, that they wouldn't obey because they're insurrectionists. They don't really recognize the authority of the president, right? So there's a really good reason to understand historically why president and vice president wouldn't be included in this list of people who would be disqualified, even if they are insurrectionists. Because if the president who sets policy is elected according to the law of the United States, which includes the Electoral College, then that's the choice of the voters. We live in a democratic republic. And the idea in a democratic republic is we all decide. This is government of the people, right? So if we elect someone president, if his views are considered insurrectionist by the previous administration, but we elect him, then that's the will of the people. That's the government that we chose. And what's happening here is something similar, something similar to what happened in the Reconstruction era. Warfare became lawfare, right? Using legal means to continue the battle. And what's happening is this whole case is an example of trying to use the law to prevent the people from expressing their will. They're keeping a leading candidate based on all the polling, off the ballot if they succeed. They're saying, if you want to vote for this person, you can't, because we have decided, based on our trial held in Colorado on a civil standard of proof, that this person is an insurrectionist. Therefore, we, the state of Colorado, are going to invoke the 14th Amendment and enforce federal law and keep him off the ballot. And that is dangerous, in my opinion. This is an important moment in the history of our democratic republic. And I actually predict that the Supreme Court is overwhelmingly going to find in favor of President Trump. And that's because actual practicalities matter. If Colorado is successful in this case, and they manage to keep President Trump off the ballot, well, I'm an old infantryman. We have a basic safety rule in the infantry, which is if the enemy's in range, so are you. If President Trump can be kept off the ballot this time around, it's going to happen again to someone who's supported by the people who kept President Trump off the ballot. In fact, it could happen yet this year. President Biden could be kept off the ballot in a number of states by using the same mechanism, because they don't have to prove anything in court. They can go on flimsy facts, have a civil standard of proof trial, and say, well, guess what? President Biden left an open southern border. That's treason. Kind of fits the definition of failure to defend, right? So next thing you know, you're going to have presidential elections where essentially you've got a handful of states deciding the presidential election because the major candidates aren't on the ballot in the majority of the state. Both wouldn't be on the ballot in the majority of the states. You'd have one candidate, Colorado would have Biden, not Trump. Some other state, I'm pretty sure Wyoming, let's just pick that one. I'm pretty sure Wyoming would kick Biden off the ballot immediately. And so you'd have Trump on the ballot in Wyoming, and you'd have Biden on the ballot in Colorado, et cetera, this crazy patchwork. So that the argument that's being put forth, the question before the court, is extremely important. Do we want chaos to reign? Do we want 50 different decision makers holding 50 different slanted, biased, civil standard of proof trials, and then using that to decide that in that court's opinion, that little trial court in one state, in their opinion, this person's not allowed on the ballot? That's ultimately what's at stake here, is the ability of we, the people, to choose the candidate of our choice. There's a lot more to this case. We could both go hours, I'm sure. But I think that's the most important point I'm going to make. How am I doing on time? Good?
Yeah, we got about 30 seconds.
Okay, I'm done.
5 minutes for Professor McLeod.
That was a very good presentation. Thank you. I just have a couple of things to say in response. I'm going to take the last part first. Folks, I think given where we are in America, we are we're in trouble either way. Because if the president, if he makes an excellent point, there might be people who try to throw President Biden off the ballot. There might be people who, who think that they've been deprived of a democratic choice. But if they find in favor of President Trump, there's going to be a lot of people who think that the court, 3 of whose justices have been handpicked by him, and who has a majority that's associated with his political party, will have just done a favor for their side and read a section of the 14th Amendment out of existence. Because it's clear to a lot of people that President Trump is an insurrectionist. They will think that they are just covering, it's just a partisan move, and that law basically doesn't exist if it gets in the way of partisan aims. I don't know that that's a better outcome. The delegitimation of the court, in the eyes of a lot of the American people, even further, and even less belief in the objectivity of the court and its nonpartisan nature. I don't know that that's a better outcome than what my distinguished colleague was saying here. Second point I wanted to make. Being knocked off the ballot is a civil disability. It's not a criminal one. So why should President Trump or anybody else have to be found guilty in a criminal case if the disability they're getting is a civil one and not a criminal one? No one's saying that President Trump should go to jail based on Section 3. He's going to get a criminal trial with all the protections of the Constitution for the criminal charges against him. Just saying you can't run for president is a civil disability. Nobody's saying that he is going to have to pay fines, that he's going to have to go to prison, that he's going to lose his liberty. None of that. He just can't run for president. Right? That's a civil disability. So why should you have to have a criminal, conviction in order to, impose a civil disability? Civil trial can do that. There is no limitation in Section 3 to the past, in the sense that there is no language in there that says it was only intended for people who had been disloyal in the last, in the preceding decade, basically during the Civil War era. They could have said that. There's other parts of the Constitution where they put time limits on things, like, for example, ending the slave trade, right? Which they said 1808, right? But they didn't do that here. They didn't say anybody who was disloyal up until 1865. They didn't say that because they said we don't want traitors taking over the government from within. We don't want that. And then another point I'll make here is that, there has never been a ruling that says that the president is completely above the law. And so when you elect a president, my colleague's absolutely right. When you elect a president, they don't often, you're electing them to enact policies that are different than maybe their competitors or their predecessors. Sure, on tax policy, absolutely. Immigration policy, defense policy, foreign policy, but not subverting the Constitution. That's not up for debate in terms of subverting it. Changing it, absolutely. But not subverting it, not going against it. Otherwise, what's the point? Our founders were very concerned that we wouldn't elect dictators, right? I would argue that that means that we have every right to hold the president and the vice president to upholding the Constitution, which they take an oath to do. They don't take an oath to enact a certain tax policy. They get elected to enact ones that are popular with the voters that elected them. But you do take an oath to, like, say, not stay in office longer than your term, which is actually specified in the Constitution. So I guess what I would say is absolutely correct. We have elections to determine policies and things like that, but not whether or not we're going to follow the Constitution. That's not up for debate. Because if it is, what is the point of all of this then? What's the point of having a Constitution? Right? I could go much more into that, but am I done?
Another minute.
Okay. I could go much more into that, except to say that I think that one of the questions that's raised by this entire incident is, can we hold it together as a country? Can we? Do we have enough trust in each other? Do we have enough ability to see the world the same way and our interests the same way and rise above whatever our parochial differences are to actually come together to agree on even a version of reality or the basic rules of our democracy? Folks, if we're beyond that, we moved beyond that once. That was the Civil War. That's what happened, right? I'm not saying that I want that to happen or that I think it's going to. I'm not predicting that. All I'm just simply saying is that's when big political changes happen, and they're not always smooth, neat, or legal. And I guess my fear is that we're at a moment where it doesn't matter what the Supreme Court decides. We're headed for the rocks either way. There's rocks on, there's, what is it? There's the Scylla and Charybdis, you know what I mean? We're hitting one of them. Because half the country is not going to believe in or be, heartily upset by and feel that the government is delegitimated by a decision, whichever one it is. I have no idea what's going to happen. I just know that, there's no easy way out of this. There's no, if we just make this decision, then everything will be fine. No. And I don't know, I don't know what they're going to do. So, thank you.
Thank you. 5 minutes for Professor Doolin.
Let me take the last one first. It's a good plan. I'm cheating and copying you. Here's what I predict. I said overwhelming victory for President Trump at the Supreme Court, right? And one of the reasons is, like any institution, the Supreme Court has its own best interests at heart also. And they understand the political thicket that is involved with this ruling either way. So I believe what's going to happen, and I am loath to predict numbers, but I think it'll be 7 or 8, maybe even 9-0. And that's going to solve a lot of that issue with the delegitimization of the court, because you're going to have the liberal justices voting to allow President Trump to continue on the Colorado ballot also. And the reason is, for some of the reasons I laid out, there are more reasons too. There are more words to fight about in the 14th Amendment. We don't have time to discuss each one of them. But there's enough there to hang any one justice to hang his or her hat on that I think we're going to end up with 7 or 8 to 1 or 2, maybe even a 9-0, and then we won't have quite the same delegitimization issue that we might have otherwise. The other thing that's worth thinking about is if January 6th was an insurrection, it's the weirdest one in history. It's the insurrection where nobody brought a gun. None of them. And so even if you use an informal dictionary definition and not a true legal definition of that term, in terms of the way it's laid out in the criminal statute, it just doesn't fit. And as far as the incitement, factually, if you look at the words that were spoken by President Trump on that day, he intentionally used the word peacefully. What he had, at least, no one knows what was in his heart or his mind. I don't pretend to, and I don't think any of us should. But the words that came out of his mouth were, peacefully make your voices heard, which is First Amendment stuff, right? Go exercise your First Amendment rights. Let them hear you. And the word peacefully was definitely included. That combined with some of the videos of Capitol police officers literally inviting those folks in to the Capitol, holding the doors open for them to walk in, and it would have been the weirdest insurrection in history. And that alone, I think, puts the lie to this entire case. It shows that it's just a continuation. Last thought, continuation of the impeachments, by the way, and that's my last segue. We do have a process for removing presidents and vice presidents and other high officials who violate the Constitution. It's called impeachment, right? In fact, this particular individual survived 2 of them. And so it's not unknown to anybody involved in this case. So if you've got a president who does decide to subvert the Constitution, that president can be impeached. There is a separate mechanism for that, not keep him from getting on the ballot so that people can't vote for him. Balance the harms, right? The potential harms. I agree, it's dangerous on both sides. But the harm, and this is in the back of the justices' minds, I promise you. The harm, if they allow President Trump on the ballot, is people might vote for him. That's your worst case scenario, right? The harm, if they don't allow President Trump on the ballot, is near certain chaos and potential destruction of our republic. That's why I make the prediction I make.
We have about 16 or 17 minutes for questions for one or both. Professor McLeod, if you wouldn't mind.
Sure.
Do we have any questions for today's speakers? Please.
So I'm clear on sort of the danger of Colorado being allowed to move forward with keeping Trump off the ballot. And there's going to be a state-by-state patchwork that seems very destabilizing to our electoral system. But if the Supreme Court overrules Colorado, we go back to sort of how it was, people will be upset, and there's this like, they'll be delegitimizing the Supreme Court in their mind, but I'm less clear on what the danger that brings is. People will be upset about the decision, but what's the practical harm?
Should I take that?
Yeah.
I'd be happy.
Person.
Several. First, if people stop believing that courts are neutral arbiters and that everything is determined already by election and who they are politically associated with, or at the state level who their donors are, then the question is, why should they feel like that court has any, because it's already stacked against them, why should they feel like that court should be the one to resolve any dispute that they have? We can look at some developing countries where governments have essentially collapsed, and that's one of the symptoms, is that people stop believing in the courts, so people stop obeying them, and people stop even bringing their disputes to them. If I'm not going to get what I think is a fair shake in court, then I'm going to deal with it myself. Or if I don't think that the decision was arrived at legitimately, why should I do what they're telling me to do? I also think that it's a dangerous precedent too, and I think that this would be a fair interpretation. I don't think it's the only one, but I think it's a fair one. If the court were to, depending on how they did it, to make it seem like they were reading too much, that they were essentially making Section 3 a nullity. Because, first of all, it would make a lot of the justices really look like hypocrites, even worse than they look right now. Because it basically looks like, well, when it's inconvenient to follow law, we just ignore it. If the political consequences are, we think the political stakes are too high, we just ignore it. If it's inconvenient to follow the Constitution, yeah, just get it out of there, because the political stakes are too high. Well, I mean, I guess I would say is that if you want to set a precedent like that, and have people think that's what you're doing, or have people look at it and think that that's what you're doing, it might not mean that much, but it might mean something quite a bit. And I can actually point at data that there was another decision that was kind of like this, which was Bush v. Gore back in 2000, where a lot of people thought that the Republican justices were 5-4. A lot of people thought Republican justices just handed it to a Republican candidate for president. The Supreme Court never really recovered in terms of its popularity or esteem after that. It was never as low as president or the Congress, but it never reached those highs again, because there was always people who said it's a political stitch-up. I don't know how low it can go, and people still believe in it. I think we're going to test that this year.
Thanks.
Yeah. Professor Doolin, would you like to respond?
No.
Fair enough. Do we have another question for one or both of our speakers? Yes, please.
So you guys didn't touch on the idea of term limits and the language that says disqualification can be taken away by Congress. So to allow 50 separate states to disqualify a president from the ballot would usurp Congress's role in removing that qualification. Can you guys touch on that a little bit more? Because that seemed like that was part of Trump's lawyers' emphasis, that even if Trump was disqualified, that he is allowed to be on the ballot. He is allowed to be elected, like you said, by the electors. And after the election, before he is sworn in, it's up to Congress to remove that disqualification. And we've seen that before historically, that there were insurrectionists that previously were on the ballot, that previously got elected, and Congress chose in both the House and the Senate to remove that disqualification. And that's the procedure that we've had since then. So why should it change now just for the president?
Great question. And by the way, for those of you who don't know, there's a site, there are two websites where you can get all this information. So we're having this conversation as people who know a lot about it already, but the Supreme Court website is very transparent. You can look up the case and read all the briefs, all the pleadings. You can see exactly who said what when. And there's another site called Oyez, OYEZ.org, where you can listen to the actual recording of the oral arguments too, and watch the transcript scroll up in front of your screen. Those are two great sources if you're really interested in anything that's before the court or has been in the past. So to answer the question though, I actually thought that was the weakest of Trump's lawyers' arguments. Basically the argument goes like this: even if my client was an admitted insurrectionist, stated that he was planning an insurrection and engaged in an insurrection, that disability could still be removed by a 2/3 vote, right? Supermajority vote of both houses. And so you have to let him be on the ballot so that people can sort of gamble their votes on him. That's why I felt it was a weak argument, honestly, because if you go vote for President Trump, accepting the fact that he's an insurrectionist or understanding that he's disqualified for the office, that's a better way to say it, you may or may not actually have your candidate take the seat because it's then up to Congress. But that is consistent with the checks and balances system, right? With the Congress being the ultimate authority on all this stuff. That's the legislative authority of the United States. So it is an argument. I understand that it had to be made. I just feel like it is the weakest of the three.
Mr. McLeod, would you like to respond?
All I would say is that there were members of Congress who were elected. They were not seated. I believe there was a guy who was in the early 20th century. He was a socialist. I forget his name. They didn't seat him because they thought he was disloyal. But then they declared the seat vacant. He won it. He ran again. He won. And then eventually they seated him. Yeah, I mean, but I agree with my colleague that I think it's not a great argument because also the Section 3 doesn't specify that that's exactly how it needs to work. It could work that way. But it doesn't specify that it has to. Do you see what I'm saying? And I think it just kind of makes more sense that if somebody's ineligible, just people shouldn't be allowed to vote for them. But I've heard that before from other people that, yeah.
Do we have another question for our speakers? Oh, yes, please.
This to both of you. Do you think taking Trump's name off the ballot abridges like free speech?
That's not an argument that's been made. Whose speech are you talking about? Trump's speech? He can still say what he wants. The voter's speech, voting is
Voting speech, yeah.
sort of quasi-speech, I suppose, and they could argue. You'd really make a more direct argument. You wouldn't wrap it in the First Amendment. You'd say it's a disenfranchisement.
Yeah, what he said, I was going to say that it's not an abridgment of my First Amendment rights that I can't vote for somebody for the House of Representatives who's 22 years old because the Constitution explicitly says that you have to be at least 25. So, I mean, that's just not a First Amendment violation. I can advocate that people should be allowed to, serve younger or, anybody can, say what they want. But, in terms of me not being able to vote for them, that's not, yeah.
More questions? Yes, please.
So, Socrates once said that democracy inevitably ends with tyranny. And I hear from both sides here that there's the two rocks that we're heading towards. Either one side is really mad or the other side is really mad. So I'm almost more concerned with the possibility, is there an issue with our voting system here where are people being allowed to vote that are not educated in the way that they need to be able to understand the truths and the untruths being presented towards them regarding this sort of thing?
Certainly, people are allowed to vote who don't understand what the hell's going on. Yes. Should we do something about it? I don't think so, honestly. Politics is sales, right? So if I can't get my candidate elected by appealing to sufficient number of voters, I've done a bad job and/or my candidate sucks.
Right, and that idea that people weren't educated enough, I mean, that was used to justify a lot of really awful things like reading literacy tests and, poll taxes and all that kind of stuff, which kept a lot of lower socioeconomic status people from voting, which was not great. But I would just simply say this, though, is that while, we can talk about whether or not electoral reform would be good, part of what any democratic system needs is sort of a modicum of agreement about values and rules. When that breaks down, doesn't matter how the decision was arrived at. If people think they can't live with it, they're not going to live with it. The South got outvoted in 1860, and they got outvoted fair and square, but their idea was, no, it's not about that anymore. You can have your government, but we can't live in this anymore. It's not about, I would argue that it's about having enough agreement on values and rules and feeling safe enough in the system that I can be in a government with these people that disagree with me. When that goes, the Constitution goes, and you're pretty much in the realm of, okay, how are we going to duke this out with power? And power doesn't just flow from a fist or from your voice, also from the barrel of a gun. Not advocating anything, hope it doesn't, but it has come to that, though. not only in this country, but in other countries. And so what I'm saying is that in the end, it's not just about the electoral system. It's about whether or not people want to be together and feel like they can be in safety and freedom. And if they don't think so, then a divorce. Some people are going to want a divorce. Now that might be peaceful, or it might not be.
We have a major agreement here. I just want everybody to know we're opposed on this debate today, but the Constitution cannot survive an absolute breakdown in trust.
Right.
It can't. You can take an L as long as it was a fair game, right? And as soon as the game looks rigged and it looks unfair and that you don't have a chance, you have to at least have a shot at victory, right? But if you don't have any chance at all, then yeah, people go to the next means. And war is the continuation of diplomacy by other means, right? You may have heard that quote before. What politics is essentially diplomacy. And that's exactly what's happened historically here and in other countries. Degeneration into outright, flat-out civil war. And I pray and hope it doesn't happen too. And I think we're far from that still. I don't think we are that far gone yet. I think we can still have these conversations, and I think we've still got enough people of good character and good faith that we're going to be okay. But it's probably going to get bumpy. Yeah, it already is, right?
Can I just add something to what he said, because I think it was an excellent point that you made? I just wanted to add that one of the things that I think is one of the greatest things about American democracy, and one of the reasons why it's been so successful, is because the stakes in our politics are generally rather low. If you're a Republican or a Democrat, if your side loses any election, you get to keep your job, you get to keep your house, they're not going to lock you up. We have individual rights protected in the Constitution. We have institutions that work well enough and enough agreement on individual liberty and freedom that you get to keep all that. So it really doesn't matter that much who wins. Do you understand what I'm saying in terms of your day-to-day life? As soon as people start to believe that that's not true, that's a problem. That's a problem. Or that if you just like, okay, lost this round, get them next time in 4 years or in 2 years or whatever, we'll get them next time. When people stop believing that, or that there is that kind of safety for them to stay, that's a problem.
Please.
I'm just wondering if there has any discussion as far as like President Trump's verbal indications of his support for insurrection. Has that been considered at all as being qualified as insurrection?
It'd be incitement, I think, is incitement to insurrection, which is actually included in the elements of the crime of insurrection. But again, the definitions in the dictionary usually involve actual violence, right? But incitement to violence is generally punishable anyway. And his words the only time his words have been considered in that regard have been by the January 6th committee that then turned into a lot of prosecutions. By the way, not a single person was prosecuted for insurrection, not one. And so President Trump's words have been considered at length ad nauseum by various institutional committees, and at no point did anybody ever charge him with actual insurrection.
Well, we're just about out of time, but before we adjourn for today, I'm going to exercise a personal privilege and tell you briefly something I admire about both of these two speakers. I want to make this public. You've heard, their excellent arguments, the passion with which they share those arguments. But when I approached Professor McLeod with an invitation to come here, his first response was, "Sure, which side would you like me to argue?" Right? And Professor Doolin I've known for a long time. He was a professor of mine during the Paleolithic era when I was a student. And we debated in class and disagreed on a point of constitutional law. And he supported my research, even though I was making an argument that went against one of his core beliefs. Both of these gentlemen believe in the academic search for truth and in learning more than anything else. And even though they disagree pretty profoundly on this issue, I hope all of you saw that they agree on what's most important in a college or university, and that is that we have debates like this and try to arrive at a common understanding of what's right. So with that, I thank both of them, and I hope you'll join me. Have a great day, everyone.
Thank you for your remarks.
My head bigger now?
Oh, thank you very much.
I'm gonna introduce you. It's all right?
Thing going on at this campus right now. Sure, yeah.
You may have met him once. President McLeod, President Dodd.
Honored to have you here. Thank you so much. Can I ask you a quick question, Professor McLeod? I want for both of you.